to precipitate a situation whereby the judiciary and the National Assembly will be on the collision course. The court is established by the Constitution to carry out certain functions. And Section 60B of the Constitution says that if you have any grievance or dispute, submit it to court for adjudication, even in cases involving Nigerians and not institutions. Once a matter is submitted to court for adjudication, you see courts say parties maintain the status quo, parties, decorous parties don't engage in self-help. This matter is before this court now. Until this matter is decided one way or the other, you are not expected. So, the National Assembly is an important institution, and I don't think that the National Assembly will do that. But if the National Assembly does that, if the House of Representatives does that, it will be the responsibility of those that have gone to court to then pick up the gauntlet and invite the court to make the necessary orders.
So, Mr. Akerega, is this your understanding of the situation? And if you were to look at it from whatever perspective, do you think that the fact that they've taken this case to court, NNPC and the Minister of Petroleum Resources, means nothing can happen until a decision is taken?
Well, I'm not a lawyer, but I think I completely agree with those positions. That once parties are in court, it becomes compelling for all the parties to wait for the outcome of what the court would say. But I would think, in my own naive position, not being a lawyer, that apparently the minister approached the court saying that she's been invited every now and then. If you do remember, she's been invited about 6 times now. So she's been in and out of the National Assembly answering to the same issue. It can really be frustrating. But that's not to, as it were, subsume that the National Assembly do not have the powers. They have the powers. I'm a lawyer. This section 8889 empowers them to ask investigate, ask questions.
And in asking questions, don't you think they ought to be raising it? If you're talking of 10 billion, it's not the kind of money you call peanuts or you use for buying small bits of thing. It's not a small change. 10 billion. If that is the case, don't you think they have a right to call 20 times the Minister of the Federal Republic of Nigeria to come and explain?
That is where I also have my problem. As an anti-corruption organization, we set up this group to actually meticulously look at issues of corruption and instability that is plaguing our country now. And what we find is that once somebody digs up a data, digs up figure and say, look, this man has embezzled 20 billion, 10 billion, 100 billion. What then flies in the public domain really is that rather they use persuasive campaign rather than facts. You know, when you plant a figure on somebody, the owners also rely on you to prove that this person has indeed embezzled those. The crux of this issue is there is a $10 billion. We are not talking about naira here. $10 billion again. 10 billion that they are saying that the minister has used in shopping, maintaining, and running a private jet. And NNPC, we've been looking at, we are very senior journalists who have been following very keenly this issue and looking at all the facts as they have been thrown up. And then also weighing them against previous issues of corruption that the National Assembly has raised, particularly the House of Reps. We are so worried that the House of Reps raise issues. We were upbeat at a point that the House of Reps do and does substantially represent the very conscience of Nigerians, going by some other landmark decisions that they have taken. But corruption issues, they've not been able to logically pursue any. And sometimes, embarrassingly so, some of them, the cycle then begins to even swallow up. Some of them will look at Henanhembe, the case of Henanhembe, the power sector, so all of that, nothing came out of them. And then Farouk Lawan.
I mean, you understand the place of facts in in investigating such matters? Have you been able to pick out any facts so far as regards this matter, saying, indeed, even if it's not to 10 billion, something that's substantial?
Yes, the NNPC has not said that the minister didn't use a private jet, and has provided retinue of, and that it is conventional in the sector. And they cited the example of the previous oil ministers, Rowan Lukman, Ajuma Gobia.
Up to 10
not even
billion.
that they've used private jets. Monies, of course, we don't use private jets without spending those kind of money. Now the issue is, what if you look at the resolution of the House of Representatives? Let me just let me because we looked at the wordings of the resolution, which for us it's a little bit it jumps to some form of conclusion for us. The resolution says, which Adeja removed, says let me just quickly, okay, says he said. Yes, Adeja said that an official of government, this time apparently is referring to the minister, could waste public funds on such luxury as chartering a Challenger 850 aircraft for extra official use. We must take note of all this extra official use, that based on reliable evidence, the Honorable Minister of Petroleum Resources has been committing 500,000 euros monthly to maintain the aircraft, and that such action amounts to misplacement of priority, impudence, and a breach of public trust, an action which offends the Fiscal Responsibility Act and all other laws on fiscal discipline.
Can you hold your thoughts? Let me quickly ask you, you are a legal practitioner. Is there a place in the Constitution that negates what the minister has done in terms of spending that much amount?
Constitution. Yes, the Constitution does not have room for such details as to how a minister...
So at what point has she erred? So
let's put this thing in proper perspective. The National Assembly and each of the two chambers of the National Assembly has the power under Section 88 and 89 of the Constitution to conduct investigations in respect of public finance, public expenditure. And what the National Assembly is doing in this one, as indeed in the other cases, ostensibly, although they have also run into their own crisis, i.e. the Lawan Farouk $620,000 bribery allegation and such things, is to say we have power to conduct oversight over public institutions in order to ensure that corruption is removed from our public life. Salutary disposition, salutary position. However, in moving against a state official who doesn't have an immunity and who therefore can be investigated that way, if that state official says, my right is infringed, or my right will be infringed, as stated by the Constitution, in Section 36 of the Constitution and Section 46 thereafter, says that, and I'm talking about the right to fair hearing and what guarantees the right to court, it is not when your right has been infringed that you can complain. Even if you fear that the right will be free. For example, if you fear in an ordinary matter that your house is going to be demolished, you don't wait for the house to be demolished. You run to court, and the court can then say, stay all action and all that. So if that state official then feels that his right is likely to be infringed and then goes to court, I'm saying, based on adherence to the due process of law, to the rule of law, that what that institution needs to do in order to avoid being portrayed as engaging in what I call legislative lynching is to stay and then allow that process To run his course, I give you an example.